Okay, let's talk about something that's a little bit technical, but I'm going to try to make it not so technical. It's the bankruptcy estate. You understand that if someone were to pass away, their property would belong to a probate estate. There would be an executor appointed to manage that estate, and there would be heirs who would be entitled to the proceeds of that estate. Well, it's an artificial legal entity, and the same thing applies when you file a bankruptcy. A bankruptcy estate is created. It's managed by the bankruptcy trustee, and it's for the benefit, and the proceeds will be distributed out to your unsecured creditors. Well, let's talk a little bit about that in terms of let's call it a basket. Let's call this bankruptcy estate a basket. Everything you own goes into that basket on the day that you file for bankruptcy, unless it's specifically excluded by federal law. For example, 401ks, IRAs, tax-qualified types of pensions don't even go into the bankruptcy estate or the bankruptcy basket. What does go into the bankruptcy estate? Your vehicles, your house, your clothing, everything that you own, and it doesn't matter where it's located. Anywhere in the world, if you have an interest in property, if it's being stored at Aunt Gertrude's house in her garage because she had room when you moved from here to there, you still have to disclose it. If it's in a storage locker at a local, you store it. Uncle Bob's storage lockers, you still have to look around your house when you're filing bankruptcy paperwork, list everything that you see, list everything that's intangible that you can't see, like bank accounts and things in a safety deposit box. I guess that those aren't intangible. Safety deposit boxes, physical items, but you're going to list interests in the right to sue somebody. For example, a personal injury claim that you have is called a chosen action, but it's intangible. All of these things go into the bankruptcy estate, and the Chapter 7 bankruptcy trustee's job is to figure out which of those assets are exempt. You help them by filing a Schedule C in your bankruptcy claiming exemptions. Incidentally, the trustee has 30 days from the time that you file your claim of exemption has 30 days from the date of your meeting of creditors to file an objection to your claimed exemptions. Otherwise, it's deemed exempt. Now, if you're going to get cute and creative and do something that's just totally in bad faith, the courts aren't going to support that. They're not going to allow you to claim equity in a $60,000 sports car that's free and clear, and simply because you claimed the exemption and the trustee didn't object to it, that exemption is going to survive. You knew that. I don't know of any state in the union where there's an exemption that comes anywhere near $60,000 on a motor vehicle. So you can't pull a fast one. There's a fairness. Bankruptcy is based on filing in good faith, but the bankruptcy estate, the resources that are there are either over-encumbered assets, meaning you owe more on them than what they're worth. So the trustee will abandon those assets and they just go to the creditors. There are assets that are exemptable and they come out of the basket. You get to keep those. And what remains in the basket are non-exempt assets that have equity, that have some benefit. The trustee's job is to sell them or liquidate those assets. That's why it's called a liquidation bankruptcy proceeding, and use the resources to pay equitably or pro rata out to your creditors based on the claims that they file in bankruptcy.